Greetings and welcome to Chapter 2, the Constitution and its Origins. Before we get started, I have a question. If we were to identify a battle cry for the American Revolution, what would it be? For me, I think back to taxation without representation. Right? The idea that the colonists were being taxed without having any representation within the British Parliament, the British National Legislature. Given that, and given that we fought and that we went to war and that we rebelled against the British government because of this notion of taxation without representation, now let's consider for a moment today 16-year-olds and their right to vote or not. Now, often when we think about this discussion about 16-year-olds, about lowering the voting age, we often think about 16-year-olds, they're not mature enough, right? They're not knowledgeable enough. They don't know enough about what's going on to make an informed decision. Can those same arguments, though, be applied to adults? Is there an adult voter that you know, perhaps, that doesn't know everything there is about politics? Can they honestly make an informed decision? Do you know any adults who aren't mature enough? Some could argue that we've had politicians who aren't mature enough to be in office, yet alone vote. So these arguments that we often hear and that we often levy, pun intended, against lowering the voting age can be applied to 30-year-olds, 25-year-olds, 21-year-olds, 60-year-olds even. So it's a good discussion to have, right? It's a good discussion. The reason why I want to talk about that here is so that when we talk about the Constitution and its origins, we can understand this document, this living document, for which lays the foundation of our government. Because after all, it's government for the people, by the people, for the people. So, let's talk about the U.S. Constitution. So some constitutional basics. Now this is true if we're talking about the state constitution, the Texas Constitution, the U.S. Constitution, or if we're talking about another nation state's constitution. This still applies. So there's some basics here. The Constitution serves as the foundation for government. That is, it creates a system of government and it establishes its power. Right? So the government, the Constitution not only lays out the system of government, but it lays out the authority and it lays out the power for which that government can exercise upon its citizens, upon society. A constitution also establishes the relationship between government and its citizens. Now, for us, we often think of the Bill of Rights, and we should. Right? The Bill of Rights is the first 10 amendments that clearly lays out protections of civil liberties. This clearly lays out a relationship between the government and you and I. There are some things that the government cannot do. And we're going to be talking about the First Amendment here today. So bear with me on that. But it establishes this relationship. And it's a living document, right? Because it can be amended, it can be changed. There's a mechanism within the Constitution we're going to talk about here that we are allowed to change the Constitution as time requires. We are still using the same Constitution that we first adopted, I believe in 1787. We'll get the exact date here in a moment. But the fact is, we can amend it. Right? There's a mechanism that we can amend it, and that we can make it form and shape it as time needs. Right? And the U.S. Constitution has been amended a total of 27 times since its adoption. So to understand the Constitution, we need to understand a little bit about history. Right? In order to understand This system of government for which we established through the adoption of the Constitution, we have to understand the road that led us there, which is the road of independence. So let's dive into this. So we have the 7 Years' War from 1756 to 1763. British and colonists, they fought against the French and its Indian allies for land. Now, this war was costly to the British. The British took the blunt of the loss, economic loss here. And in order to recover some of the money, it imposed taxes against the colonies. So this was a way to replenish money that the British had lost during this time, right? We get the Sugar Act of 1764, which placed taxes on sugar, coffee, and other products. Now, we didn't have Starbucks back in 1764, but you can imagine, right? Here you are, you're a colonist, you're in a colony, you are getting your morning coffee, and then all of a sudden, it's jumped, it's skyrocketed. It's exponential in cost now. It costs more. The sugar costs more that you have to use. You can imagine that people might have been just a tad upset. Right? The Stamp Act of 1765, 1 year later, placed taxes on all paper goods such as diplomas, land deeds, contracts, newspapers. We have to understand something. We did not have Twitter. We did not have social media. We did not have the internet. The way to get news was to talk with one another and to read your local newspapers, right? So to see taxation, increased taxes now on all paper goods, you can imagine again this might have upset some people. The Quartering Act of 1765, though, required colonists to provide housing for British troops. British troops could literally just, you can imagine this, right? You can imagine this, that a British soldier coming to your house, knocking on your door and going, this is my house now. You're going to have to house me and feed me and basically take care of me, rent-free. You can imagine this didn't set well, right? And you can begin to smell, right? You can begin to smell the Constitution here, right? Because we're gonna look at one of the amendments that basically forbids this act. More on that in a minute. We have the Townshend Acts of 1767, which placed taxes on tea, glass, and paint. So we have taxes now on tea, sugar, other products. We have taxation now on paper goods. We have taxation on tea, glass, and paint. It seems like no matter what it is, it seems like there's now increased taxation on this. Which leads us to conflict, right? We begin to get, colonists begin to uprise, we begin to voice our frustration, and we had the Boston Massacre of 1770 and the British Tea Party of 1773. Now we're having what the British might call acts of terrorism. Right? The British, you can imagine their viewpoint of the colonists at this moment in time. We were terrorists. We destroyed property. We destroyed goods. We rebelled. Right? You can imagine that they would, for political means, right? For political gain. We did all this in the name of politics, in the name of freedom, nevertheless. But you can imagine from their point of view, they probably called us terrorists, right? But I digress. The point I'm trying to get here is we went from being upset, now we are protesting, now we are trying to list our grievances, and now we're clashing with the British here in the colonies. We have the Coercive Acts of 1774, a series of laws intended to punish Boston for leading resistance to British rule and to restore order in the colonies. So they abolished town meetings. Now, we have to understand a little bit here, especially within Massachusetts, modern day Massachusetts. This form of democracy, town hall meetings, this is built in our DNA. This is part of being American almost. That we have these town hall meetings that we can get together, that we can voice our concerns of policy. We can voice our disagreement with government. We can voice our grievances towards the government. And this is done out in the open in this town hall. Well, now with this town hall being banned, we have taxes, and our ability now to complain, our ability to rally and to voice our concern is now being intruded upon. Again, you can start to smell the Constitution here with the First Amendment, regarding the idea of free speech. Right? Bear with me. We will get there. You'll see what I'm talking about here in a minute. But all this is leading us to the Constitution. So, we have the First Continental Congress of 1774. Members of the institution developed a Declaration of Rights and Grievances, not only of Declaration of Rights for the colonists, but also a list of grievances towards the British government. Right? Then we had the Second Continental Congress in 1775, where George Washington was appointed to lead the Continental Army against the British if war to war occurred. Now, of course, we know, hindsight, this is the past. We know we did. We went to war with the British. But here is when George Washington was appointed to lead that army. Now, 1776. Now, the Declaration of Independence, right? This is the document that was drafted by Thomas Jefferson that formally separated the colonies from the British. This is where we said, okay, enough is enough. This is our Declaration of Independence. We are going to, you have our list of grievances. You know why we're doing this, right? So here's our formal declaration of we're done, right? To use different terminology, we might say this was our divorce, right? This was our divorce from the British government. That this was finalized. We've had enough. We said, nope, not doing that. We're out. So, our first attempt at government, at self-government here among the colonists, were the Articles of Confederation. Now, this was the first basis for the new nation's government, and it was adopted in 1781. It created an alliance of sovereign states held together by a weak central government. Okay, so the states here at this juncture, okay, the states had all the power. Had all the power. It was the states. They had all the power under Articles of Confederation. There was a weak national government, but it was so weak it could not function. It couldn't even levy taxes among its citizens in order to have a revenue stream to raise an army or a navy. It did not have any type of revenue to since it couldn't tax, it just couldn't function. to put it bluntly and simply, it just couldn't function. So, so what is a confederation? Right? A confederation is a highly decentralized form of government. Sovereign states form a union for the purposes such as mutual defense. So the states, right, under the Articles of Confederation, the states had, like I said earlier, had all the power. So foreign policy was left for the states to decide. And the states would agree mutually to defend one another. But could they? Articles of Confederation, one of the critiques about it is it was just too weak. The states had so much authority and so much power under this form of government that the national government was basically pointless. Basically. It couldn't squash rebellion within the states. It couldn't tax. It couldn't build an army or a navy. It couldn't function. So Articles of Confederation was our first attempt, and it wasn't that successful. Characteristics of the Articles of Confederation. Congress consisted of a one-house legislature instead of a two-chamber legislature that we have now. More on that. We'll get to the Constitution part in just a second. The government did not have an executive branch as executive decisions were made by special committees in Congress. So within this one-house legislature, within this one-house Congress. Congress lacked power to regulate commerce, levy taxes, as I said earlier, prohibited states from creating their own currency. So each state had its own currency. Could you imagine if Texas was part of the Union at this juncture? Could you imagine what our money would have been like? Our currency would have been like? Could you imagine what each state having its own currency? It's insane. I say it's insane. It would be hard for me to imagine going to another state, visiting another state like Louisiana or Florida or Massachusetts or Oklahoma, and having to do a currency exchange. Right? It seems a little wacky for us, I suppose. Anyways, I digress. In order to pass a bill under the Articles of Confederation, 9 out of the 13 states at this time. Remember, at this point, the United States only consisted of 13 states. So 9 out of the 13 states were required for approval, and unanimous approval was required to amend the Articles of Confederation. You can imagine getting 9 out of 13 states. This would have been difficult to do. Right? Each state has its own interest, if you will. We're going to get into this conversation way more here in a moment when we start talking about representation. Representation of small states versus large states. We can see interest at work here. But Articles of Confederation really didn't allow flexibility, not only in terms of the national government, but it just gave so much authority to the states, right? So, which leads us to the Constitutional Convention, right? So we've had these lists of grievances. We've rebelled against the British government. We now are creating our own. We did create our own. It was a little too rigid. It didn't quite work out. So here we are, September 17th, 1787. We have the Constitutional Convention. It was held in Pennsylvania at Independence Hall. We had 74 delegates were appointed to attend. 55 only attended. Only Rhode Island did not participate. So 13 states here so far, Rhode Island just did not participate in this convention whatsoever. They had no representation, if you will, at this convention. George Washington was elected president of the convention, and James Madison became known as the father of the Constitution because of Madison's notes that he took during the convention, and he provided a handwritten, detailed record of the proceedings. Interesting enough, though, real quick, just to note this, James Madison also penned the Bill of Rights. So you can imagine, right? You can imagine at this convention, we're talking about the convention that would make up the U.S. Constitution. We're talking about a convention where people gathered to lay out this new form of government. Now, I don't know, I'm just thinking here. Could you imagine the arguments? I would have loved to have been a fly on the wall at Independence Hall to hear these arguments, right? Because 13, well, Rhode Island didn't attend, so we have 12 states, right? We have 12 states here, each having different opinions. After all, this is politics. I can imagine, right, the debates that were sparked and the discussions that were being had. I would love to have been a fly on the wall for this. But as we know, as we learn more about politics and as we observe politics, opposing political groups were beginning to form, right? So first, let's talk about the Federalists. The Federalists were those who supported a strong central government and the ratification of the U.S. Constitution. This group was led by Alexander Hamilton, James Madison, and John Jay. We have the Anti-Federalists. They were led by Patrick Henry and Samuel Adams. They supported strong state powers and opposed the ratification of the U.S. Constitution, this new document that was being drafted, this new document that was going to replace the Articles of Confederation, and that we were going to create this new government now from this new document. So just a quick recap here, right? We have the Federalists who argued for a strong central government. Let's reword that. We had the Federalists who argued for a strong federal government, and then we had the Anti-Federalists who wanted strong states' rights. Does this sound familiar? I mean, it kind of does, right? The Federalists today would be Democrats. The Anti-Federalists could be well argued that would be the Republicans, right? Because we have the Democrats who are arguing for a stronger federal government, and we have Republicans arguing still for a smaller government. So that means more rights to the states. That states decide decisions on issues that are not forbidden by the Constitution, right? So these two opposing forces, these two opposing groups here at this convention, we still see that today, right? We still see that. Anyways, so some issues at the convention, right? Representation in the national legislature, that is the U.S. Congress. This was a huge debate, right? This was a huge debate, right? Because we're talking about the representation. We're literally talking about how representation is going to be done, right? So we had the Virginia plan, which was a plan for a two-house legislature. That means a two-chamber legislature. Representatives would be elected to the lower house based on each state's population, and representatives for the upper house would be chosen by the lower house. So this Virginia plan, right? We would have this lower house that based upon the state's population size would determine the representation, how much representation you would have there, and then the upper house would be chosen by the lower house. Right? The New Jersey plan the state of New Jersey did not like this plan, did not like this at all. So New Jersey put out its own plan, and it advocated for a one-house national legislature. Each state would receive one vote. Why? Well, we can start seeing states' interest here, right? Virginia was a large state in terms of population. New Jersey was not, right? So for Virginia, it wanted to make sure that its interests were reflected in the national legislature. How do you do that? Well, make sure that states with large populations had the most votes or the most seats in the national legislature. New Jersey, being a smaller populated state, saw this and went, no. It should be equal footing. One vote. We should have one house legislature in every state, regardless of your population size, one vote. Indeed. Well, they clashed, right? And ultimately what we get is what's known as the Great Compromise. Here, we're talking about representation still. It's a combination of the New Jersey plan and the Virginia plan put into one. The state of Connecticut, the delegates of Connecticut, put forward this new plan, this Great Compromise. So what it did was it created the national legislature and its representation that we have today. The U.S. House of Representatives, okay, it's based upon population size. Depending upon how populated you are, depends upon how many seats you receive in the U.S. House of Representatives. Every state gets exactly 2 senators. So that means every state gets exactly 2 votes. Period. Full stop, right? So we have the states who have large populations, Texas, California, right? We have the most seats within the U.S. House of Representatives. But regardless of, like Rhode Island is a very small state with a very small population. Nevertheless, though, in the U.S. Senate, it gets 2 votes, just like Texas does, just like California does. So we see a combination here of the Virginia plan and the New Jersey plan. And this is called the Great Compromise. So the U.S. Constitution, we often think about it as this beacon of freedom, that it creates this new form of government, and we experience this new form of government that is this shining beacon of freedom. Unfortunately, the U.S. Constitution has not always been that bright beacon of freedom. So American slavery, the 3/5 compromise. This is that one slave is 3/5 of a person. We are dehumanizing people here. The U.S. Constitution literally dehumanized people. This is a very dark time for civil rights and even for civil liberties. It's a very dark time. Like I said, the U.S. Constitution wasn't always this bright beacon of freedom. Not for everyone. Fortunately, though, it later did fulfill that. It later did become this bright beacon, but at this juncture, it was not. The slave trade will continue until 1808, and under the Constitution at this time, runaway slaves must be returned to the original owners. So, not always been that bright beacon, but it later would be. Constitution and the economy, right? So, Congress was granted power to levy taxes, regulate interstate commerce. That's commerce between states, right? Interstate commerce between Texas and Louisiana, or right. So the Congress, the national legislature, now can regulate that trade, that exchange between state lines, and of course, the federal government now can coin money. Charles Beard argued in the book Economic Interpretation of the Constitution of the United States back in 1913 that the Constitution was supported by the framers due to favoring wealth and business interest. We kind of see that, right? Back with regarding how representation was going to be done. Is it going to be done, should each state get 1 vote or 2 votes, or should it be based upon population size? Right? We could almost see those economic arguments being had in the convention. Like I said, I would have loved to have been a fly on the wall to hear those debates. So, under the U.S. Constitution, one person was chosen over a multiple executive, right? We have the selection, we have the electoral college, which is going to be chosen over direct popular election and selection by the Congress. So we have the electoral college here, right? The term of office, 4 years, was chosen over 7 years with no term limits. So at this time, right, 4-year term, we're accustomed to that. Right, we chose this over 7 years with no term limits. Here we go. So that electoral college. So we're going to break down electoral college a little bit now here. So let's talk about this. So electoral college. It's often, when we think about it, we often tend to overcomplicate it, to be frank. It's nothing more than a reflection of our own government. Here's what I mean. Do you and I represent ourselves? Do you and I represent ourselves in the U.S. House? No. Do we represent ourselves in the U.S. Senate? No. We elect someone to do that on our behalf. Electoral college is very similar. We elect a delegate, and we'll talk about the selection of those delegates later in later videos. But we will get there. But the Electoral College, we elect a delegate to cast their vote directly for the president. So it's a reflection of our representative government that we have, this Electoral College. And we'll dive into how those delegates are elected when we get to political parties. But for now, just note, Electoral College is this idea that we elect a delegate to cast directly for the vote for the president. And we still use that system today. So going back to the Anti-Federalists. All right, so the Anti-Federalists, led by Thomas Jefferson, they feared a strong central government because it would favor the rich over the middling sort, the middle class. We're still, even back then, we were talking about the middle class. So they feared a strong central government would become tyrannical. Right? This idea that the strong central government would basically become Britain. Right? This idea that we just broke up. We just broke up with the British. Why would we want that same relationship or attempt that relationship? Right? So the idea here that the Anti-Federalists feared this strong central government. They opposed the Constitution because it did not include, at the time, a Bill of Rights. Well, going back to the Federalists, they, led by Alexander Hamilton, they asserted a strong government would be better for both national defense and for economic growth. Now, obviously, we know the Federalists won this argument, and they won it based upon this: national defense and economic growth. And they argued that a Bill of Rights was not necessary at all, but eventually they did agree to add the Bill of Rights in the first Congress. What's actually interesting to note here is that James Madison, he said, why? What's the point to a Bill of Rights? A Bill of Rights is nothing more than parchment paper. If a government wants to violate your civil liberties, no piece of paper is going to prevent that from happening. And he's right to a degree, right? I mean, think about it. We have posted metal speed limit signs. Do we obey them? Be honest. Do we obey them? No. Right? At least that's been my experience so far here in Houston. But the point I'm trying to make here, right, is that no piece of paper is going to prevent anyone, especially in government, from taking away or violating your civil liberties. So for them, the idea of adding a Bill of Rights was meaningless. To them, they thought this was pointless. There was no need for this. Because in the end, a piece of paper is not going to stop anyone. Right? That's the idea here. So, though, nevertheless, they agreed perhaps the first political compromise in U.S. history. Right? This idea that, okay, Anti-Federalists, we hear you. We will adopt, in the first Congress, we will pen a Bill of Rights. Interesting, right? The Federalist Papers was a collection of 85 essays, 85 essays written by Alexander Hamilton, James Madison, and John Jay in support of the ratification of the Constitution. The Federalist Papers could be viewed as the first political campaign materials. This was a collection of essays that articulated very well and drove home the points of we need a constitution. We need this constitution. We need this democratic republic federalist government. We need this. Here's why. It was a very articulated which clearly laid out its arguments for this new government. It's an interesting read. So the Constitution was, in fact, adopted on September 17th, 1787. Okay, 1787. We celebrate this day every year on September 17th or around September 17th. We celebrate this with Constitution Day. We observe this moment in history that the U.S. Constitution was adopted on September 17th, 1787. It was also it was ratified on June 21st, 1788, with New Hampshire being the 9th state to approve the Constitution, to approve the ratification of the U.S. Constitution. Interesting, right? So some characteristics of a Constitution, kind of going back to where we started with the basics. It is, in fact, a written document. It establishes, like I said, the relationship between the central government and its people, including civil liberties. To a degree, even talks and establishes the relationship between the federal government and the states. That's an interesting component as well. We'll talk more about that when we talk about federalism. So that would be, if I remember correctly, that's more chapter 3. So we will talk about that relationship. But right now, we're going to focus on the creation of the national government and its relationship with you and I. So it establishes a relationship between the central government and its people, including civil liberties. It assigns powers and duties to government institutions, along with limitations. Yes, limitations. So, does the president have all power and authority? Well, yes and no. Does the president have all executive authority? Yes, Constitution makes that clear. But does he have or does she have the power to pass legislation, to create laws? No. No, they do not. Can they reallocate funding from one project to another? No. Let me be very clear about that. No. Right? Passing legislation, appropriating funds, meaning allocating funds for a project or for a program, that is solely at the discretion, according to the Constitution, under Article 1. That's clearly the function of Congress. And the president doesn't have that authority. But the president does have the authority to make treaties, to be the commander-in-chief. They do have all the executive authority, but that executive authority is, in fact, limited. Right? So the Constitution, like I said earlier, it establishes this form of government, but also places some limitations. Right? So I digress. It defines the relationship between the central government and smaller governments, i.e. the states. Right? What's this relationship going to be like between the federal government and Texas, the federal government and Florida, right? The federal government in Massachusetts, the federal government in Rhode Island, right? It establishes that. It lays out that framework, right? And it also provides a method for amending the document, right? I've already hinted and mentioned this already, right? It's a living document because we have mechanisms built within to amend it. So if I've said this now, this will be my second time. I wonder if that's important to note. Anyways, let's move on. So, continue on. Right, we have representative democracy. To learn more about this, go back to the previous. Go back to chapter 1 and chapter 1 lecture video where we talk about representative democracy. But it establishes that. We have the civil liberties that are protected, right? These are limitations on what the government can do to you and I. This is the first 10 amendments to the U.S. Constitution. This is known as the Bill of Rights. We have clear separation of powers, the sharing of powers among three separate yet equal branches of government, right? I have a typo there. The word legislatures shouldn't be there. My apologies for that. But nevertheless, right, we have these separation of powers that the Congress cannot operate fully, right, without the president. The president cannot operate without the Congress, and likewise, the judiciary can't operate without either one of these. But they operate separately from one another, right? So, and we also have systems of checks and balances, right? So, for example, separation of powers. Can the U.S. Congress make laws? Yes. Can the U.S. Congress implement those laws? No. No. The U.S. Congress, the legislature, when I say legislature, so it doesn't matter if we're talking about the state legislature or the federal legislature. Only the legislature has the ability to make laws. It's up to the executive branch to implement the laws. Does the U.S. House or does the U.S. Congress have the ability to interpret the law? No. That is the discretion and assigned duty and responsibilities of the judiciary, of the U.S. Supreme Court. So, I call them co-equal branches of government, right? The three branches, the legislature, the executive, and the judiciary. But note that they operate independently, right? Yes, they need one another, right? The U.S. Supreme Court, to get appointed to it, the U.S. president must appoint a nominee. Then it's up to the U.S. Senate to confirm that nomination, right? So they all work together. So they're co-equal branches, and there's not one that's more important. The president, let's be very clear, the president is not more important than the U.S. House. It's not more important than the U.S. Senate. It's not more important than the U.S. Supreme Court. They are co-equal branches of government. They are all three co-equally important. Okay, that's what we need to take away from this. And they also have their own responsibilities, their own powers, for which only they possess, right? So going back again to the U.S. Congress. The U.S. Congress, we're going to dive deeply into what they do in another chapter video. But for right now, just note that they're the only ones that can make laws and appropriate funding. That is to allocate money, allocate funding. They levy the taxes and they allocate where those taxes go to. Only the legislature can do that. The president, the Supreme Court has no direct input on that. Only they can do that at their will. The U.S. The president, only they can make the appointment to the Supreme Court. But yet at the same time, though, they have to get the confirmation from the U.S. Senate. So you see how all this works out, right? We have separation of powers. Responsibilities are broken up. We have checks and balances, a system that allows one branch of government to limit the exercise of power by another branch, requires different parts of government to work together. So, beyond some of the examples that I've already mentioned, or hinted at, perhaps is a better way of putting it, but what are some examples you can think of? Well, for me, there's too many to just put my finger on one. But the appointing judges to the U.S. Supreme Court, this is absolutely a system of checks and balances, an example of checks and balances. The president gets to appoint, but the U.S. Congress, specifically the U.S. Senate, they have a say in this process. They have to confirm this nomination. Now, typically it happens. Typically the nominations go through and there's not a problem. But what we should take away from this right now is that the president can't just appoint and then it's done, right? There's a system of checks and balances. Another one is how legislation is made. Here's what I mean. U.S. House, the U.S. Senate, they agree to a bill. They both agree that this bill needs to be passed, and they pass it. Fantastic. We're on a good path. But what can happen is the U.S. president, when the bill gets sent to them, the president has the power to veto it. Say, no, I don't like this bill. For whatever reason, for whatever he or she thinks of it, doesn't matter. I'm going to veto it. Now, of course, if Congress is popular, if there's a high level of trust in the legislature, if this is a bill that is popular among the people, vetoing it may not go well for the president, but it's at their discretion. They can do that. They can veto it. Now, the legislature, is this, oh, well, it was vetoed, we're done? Do they just pack up and just move on? No, right? They can overturn that veto with the 2/3 majority vote in both chambers of Congress. So we got the House and the Senate. So we can overturn that veto. So there's that system of checks and balances there, right? Moving on. Federal system, a form of government in which power is divided between state governments and a national government. This is where we see here that power is divided. It's shared between the federal government and the sub-level or the state level, right? Federal government has powers and authorities and authority. The states have power and authority as well. It's shared. We'll dive deeper into that discussion when we talk about federalism. Okay. But let's continue on. The National Supremacy Clause. This is a statement in the Constitution that the federal law is superior to laws passed by the state legislatures, i.e., it's again National Supremacy Clause. Okay, I like to think about this in the context of spades. Right, if you ever played the card game Spades, right? It's this idea that the Ace of Spades is the highest card in the deck, right? The Ace of Spades will trump, pun intended, because I love my puns. It trumps every card in the deck, every other card, right? It trumps everything. So we have the Ace of Spades. The second highest card in the deck is the King of Spades. And the third highest card in the deck is the Queen of Spades. Right? So the federal government, according to the Constitution here, because we have this Supremacy Clause built into the Constitution, the Supremacy Clause here clearly states that the federal government is the Ace of Spades. The King of Spades is the state government, and the local government being the Queen. Right? So I say all that to get to this main point that the National Supremacy Clause clearly states is built into the Constitution. The framers of the Constitution intended for this, that the federal government can supersede, and it does supersede, state and local governments. That when there's a conflict between the two, we see that the federal government supersedes you. It overrides. And it's built into the Constitution. Let's keep going here. So amending process. In the Constitution, we have two methods of amending this Constitution, this living document for which establishes our government. Right? There are two methods. Method one, it's by 2/3 approval of both houses of Congress, right? That 2/3 approval from both houses of Congress, and we get to amend the Constitution. The second method is a constitutional convention called by Congress upon the request of 2/3 of the states. Now, it should be noted, we have never used this method to amend the Constitution the 27 times that we have. We do not use this mechanism, this method, I mean. We don't. Instead, we use the 2/3 approval from the House and the Senate. That's the way we've amended the U.S. Constitution to date. But nevertheless, both these mechanisms are baked into the Constitution. So, the method 1, right, by 3/4 approval of the state legislatures is required. Once the House and the Senate agrees to amend it, we have to have the 3/4 approval of the state legislatures agreeing to this amendment. Under method 2, again, we have not used this method, but under method 2, by state ratifying conventions called by 3/4 of the states, the 21st Amendment, repeal of the Prohibition, 18th Amendment. So method 1, this is the method we've used, and this is how it's done. Right? The House and the Senate, they propose this new amendment to the Constitution. It gets sent to the state legislatures, and we must receive 3/4 approval in order for that to become new, in order for that to become for the Constitution to be amended. So sharing power, right? This is the idea of checks and balances here, right? So judicial interpretation, right? Judicial review, by definition, is the court's power to interpret the constitutionality of a law or executive action, rather. So the Supreme Court cannot review a law. So the Supreme Court can't make a law, right? They can only interpret what has been done, this new law that was passed, or this new question that is before them. They can only look at it through the lens of the Constitution. Is it constitutional? Yes or no? If yes, why? If not, why? You see what I'm saying? So they can only review. They cannot create. They cannot implement. They cannot enforce. Rather, they only interpret the Constitution. And the questions that are sent before them, they look through it through the lens of the Constitution. Judicial review originated with the case Marbury v. Madison of 1803. We're going to dive into that case later in the semester, so don't worry about that right now. Just note here that judicial review is the court's power to interpret the Constitution. Now, there is a discussion here about Ruth Bader Ginsburg. Justice Ruth Bader Ginsburg made the assertion that this judicial review was implied, meaning the Supreme Court was created by the framers of the Constitution. We have the executive, we have the legislature, we have the executive, we have the judiciary, and obviously, that this is here to serve as a mechanism in this checks and balance system. But it was not explicitly written, so it was only implied. Marbury v. Madison here made it explicit, right? It is now explicit. This is their duty. This is their responsibility. Anyways. Presidential and congressional action. Again, talking about this power sharing. Thomas Jefferson authorizing the purchase of Louisiana Territory in 1803. Congress attempted to limit the president's military powers by passing the War Powers Act of 1973. So we got a lot going on here, right? So the president purchasing, allocating funding here, right? Create well, not really allocated funding because that's up to the legislature. But you see where I'm going with this, right? This idea of authorizing. The president is negotiating with, I believe, France. If I remember correctly, it was with France here. He was negotiating with France to purchase Louisiana, right? So the president started those negotiations. Then the U.S. Congress allocated the funding. The president authorized it. It was up to the U.S. Congress to provide it, right? So we see some, even with this one act here, right? We are seeing some sharing between the president and the Congress. War Powers Act in 1973. So we're going to dive into this when we get to to the president chapter. But for now, just note that the president, according to the U.S. Constitution, the president is in fact the commander-in-chief. He is the she is the commander-in-chief, Okay, but the U.S. Congress is tasked under Article 1 of the U.S. Constitution. They are tasked with maintaining an army and a navy, right? They are tasked with building and maintaining our national defense, in short. So there is the relationship here. There's some overlap that is shared, is what I'm trying to get at here with this. And the U.S. Congress in 1973 tried to assert themselves more into the president's ability to wage war back in 1973 by implementing this resolution, or this War Powers Act, that put some stipulations on how long the president can use military troops. We're going to dive deep into the War Powers Resolution later on. So, but for now, just note that we're seeing shared responsibilities, and that the Congress and the president both play a role in this power sharing. So custom and practice, right? The existence of political parties, the creation and expansion of the bureaucracy, right? The Federalists and the Anti-Federalists really did kick off our political parties that we have here. We'll dive more into political parties in another chapter, but just for now, I feel like I've been saying that a lot, right? But anyways, the existence of political parties, we starting to see that coming from the U.S. and from the Constitutional Convention. We're seeing that come out now. And the creation and expansion of the bureaucracy. Well, of course, in the beginning of when the Constitution was first formed, of course, we were seeing this expansion. But we're seeing that still today as new problems come up, as more programs are designed and executed and implemented and created to address these issues. We're seeing an increase of the bureaucracy. Now, it's up to your ideology, my ideology, to assess, do we need that? Is that a good thing? And we can boil that down, in essence, into a anti-federalist, federalist argument to a degree, right? Should we have a stronger, more expansive bureaucracy, i.e. federalism, a federalist argument, or should we have more of states handling these issues? Wherever you may lie on that particular position, it may honestly depend upon the political issue we're discussing. Might depend upon where you think that responsibility lies. We're going to talk more again about this federalism next time, so bear with me. So some important amendments, right? We're going to dive deep into the civil liberties. But for now, the Bill of Rights, the first 10 amendments, right? We have freedom of religion, speech, press, assembly, and petitioning of the government, giving them a list of grievances. The Second Amendment, the right to bear arms. This is where we get the idea of, we have the right to a firearm and other types of weapons. Then we got the Fourth Amendment, the protection against unreasonable searches and seizures by the government. We have the Fifth Amendment, protection against double jeopardy. That is the idea that I can't be tried twice for the same crime. I'm protected. I can plead the Fifth, and in other words, not say anything, because what I may say, what you may force me to say, may incriminate myself. I have the right not to do so. I have the right to plead that Fifth. Which I don't know about you, but when I was a kid, I pleaded Fifth a lot. But we also have the creation of eminent domain. That is the idea that the government can seize land, but they have to give the landowner just compensation for the seizure of that land, for the taking of that land by the government. We have the Sixth Amendment, the right to a speedy trial and having the right to an attorney. The Eighth Amendment, protection against cruel and unusual punishment. Amendments 11 through 27. We have the abolishment of slavery. We get that with the 13th Amendment. We have the right to vote cannot be denied on account of ethnicity. And we have the 16th Amendment, which created the federal income tax. The 17th Amendment, direct elections of the U.S. senators. See, back prior to the 17th Amendment, our U.S. senators were selected by the House legislatures, by the legislatures in the states. They got to decide. They got to elect for us our U.S. senators. But that was changed. We had with the adoption and ratification of the 17th Amendment, what we get now is a direct election where you and I get to do that. The 19th Amendment granted women the right to vote. We have the 22nd Amendment limits the president to 2 terms in office. It was a custom, it was a practice of the president to, of course, serve just 2 terms. That came from George Washington. After his second term in office, George Washington stepped down from the presidency and said, basically, I'm done. But I do not want to be the king. I do not want to go beyond these 8 years. So he set the standard. He set the practice and the custom for that. Fast forward many years to FDR, Franklin D. Roosevelt. He broke that tradition because of the war, World War II, right? But after World War II, we get the ratification of the 22nd Amendment, which clearly states in the Constitution now that the president is limited to 2 terms. Right? We get the 23rd Amendment to the U.S. Constitution, which granted electoral votes to the District of Columbia. And we get the 26th Amendment, which lowered the voting age to 18. Prior to this, I believe it was 21. Prior to this, you had to be 21 years of age. But I can almost imagine, going back to the opening of this video, I can almost imagine that opponents of the 26th Amendment said 18 is too young. What do they know at the age of 18? They're too immature at the age of 18. But I digress. So, now, again, going back to this idea of power sharing one more time. Word analysis of the Constitution. This is where we're wrapping up the video here. Right? So the word analysis of the Constitution. If we were to take a look at the word count of Article 1 of the U.S. Constitution, it would be 2,268 words. Take a look at Article 2, 1,025 words. Article 3, 377 words. Now, Article 1, remember, establishes the U.S. Congress, i.e. the legislature. Article 2 establishes the executive branch, that's the president. And Article 3 establishes the judiciary. So, what does this imply? Does it imply anything? It's a good question. And I would say, yeah, it does. Consider for one moment, right? The framers consider Article 1, Article 2, and Article 3 to be a laundry list. These are lists of responsibilities, right? You can imagine almost like as if your parents were to give you, or maybe your spouse gave you a list of responsibilities, right? A list of things to do. Well, 2,268 words. That's a big list. That's a lot of responsibilities compared to 377 words, right? Or Article 2, 1,025 words. It's more than 377, right? So this idea that I'm trying to articulate here is that the framers of the U.S. Constitution intended the U.S. House and the U.S. Senate to have the bulk of the responsibility. Their responsibilities, their powers that they have to deal with this, it's more extensive, right? They've always intended for the Congress to bear the majority of the responsibility. And so likewise, the president under Article 2, they have authority and power, yes. But the idea here is that perhaps they were intended to have a little more than the U.S. Supreme Court. I do not know if the framers intended for the U.S. Supreme Court to have the power that it has today. Maybe they did. And maybe that's the reason why it's so vague. Don't know. But the idea here is that it was always intended for the U.S. House and the U.S. Senate, the U.S. Congress, to have the majority of the power. Why? That's an excellent question. That question can be answered simply by looking at how frequent our members to the legislature are elected. Remember, the U.S. House of Representatives, they're up for re-election every 2 years, which means that we, the people, we hold them accountable very, very frequently every 2 years. Now, that's not the case with U.S. senators. They're up for re-election every 6 years. But nevertheless, the point here is that the U.S. House of Representatives, where they have the majority of the power, right? We elect them every 2 years. They are held responsible by us, and the framers intended for you and I to do that. With that said, this concludes this video. I would say that if there's anything I've said so far that you have any questions, thoughts, or comments about, please feel free to give me an email. Till then, we'll see you next time.